So today is day one of the APRocky trial. It is California versus Mayer, and do keep in mind that they are in California, so there is going to be a time difference, so some videos are going to be delayed due to that. But let's get into it. So they had an issue that they had to deal with before they could even start opening statements, and let's talk about it. Now, the jury was sat yesterday. One person that I thought was interesting from what I've heard so far about the jury is that one of the jurors is a weapons instructor, and so I personally think that's a good thing to have an instructor on the jury. I think that may go in his favor because their level of knowledge is just going to be quite there and helpful, so she can explain. I believe it is a woman that is the one that's a weapons expert. But she'll be able to explain information very well to the other jurors when they're able to go back and talk about things. And she should be able to bring it to a realistic level of knowledge to people who may not, know a lot about weapons. So the issue that they had is that the prosecutors had received an email that was, hey, did you look at this report? And it was like, I don't have this report. So they are stating that the report was done, but somehow none of them got it because the lead detective, I believe, which is Flores, did not send it over to them, even though it was done, based on the casings that the victim ended up finding later on because of the way the locations kind of spread out. So they are like, we have this report, we want to use this report, but we did not find out about this report until yesterday. We did go through all of our stuff. It was not in there. They're just like talking about how they believe that this report needs to be used in their case. And so the judge does allow for the prosecutor to explain kind of what happened, what are the steps that took place, and it goes from there.
The expended casings were turned into the police.
The day of the incident.
It would have been 2 days later when he reported it to the police.
In other words, back at the time this happened in 2021.
All right, so the incident occurred on November 6th, so it would have been around November 8th?
Yeah.
All right.
So he turns them in. There's work done on the casing, unbeknownst to co-counsel, myself, obviously I was not on the case. They ended up doing a further examination of the casing. That examination revealed that, in fact, the two casings are consistent with having been fired. They're 9mm casings from certain 9mm handguns. There are some markings on the casings that are somewhat unique, and they can basically track them down to a much smaller subset of firearms that could have caused the marks on the casings. The examiner will testify that the markings he has seen very rarely. So the way this came about was we were looking at a different issue. The detectives yesterday afternoon sent an email to my co-counsel basically saying, hey, take a look at that report, this report that we're talking about.
Which detective?
In the attached it.
Detective Flores.
Flores?
Flores.
From Robbery Homicide?
Yes.
Go ahead.
So when this was received, my co-counsel looks and says, I've never seen this report. So he goes back in discovery, looks at emails. We don't have the report. So we instantly contact the defense, send them out the report.
I don't want to get into who said what. I just want to know the sequence of events.
Got to get up and give his stance on how he felt about how everything's playing out. And he said, sir, Detective Flores, the lead on the case, telling y'all last minute report, I'm not for it. He said, I don't believe y'all. This sounds like a lie. I'm not for it. Everything got to go. Let's start all over. He said, I want this done. Let's start from scratch because y'all playing with us and we not about to play games. Back with y'all. He was quite upset. He was real upset. The judge was like, what are you seeking? He said, I want to start over. This is too damaging, Judge. I don't think we can go forward. This is some mess. He said, no. Y'all trying to play games. How y'all get this report just yesterday? And nobody thought to ask about this report? Nobody even thought that the report would be done. That y'all didn't ask about it before yesterday? He said this is damaging. They should have had this before now. They should have known that they were missing this before now. I don't think we can go forward. It needs to be a wrap. He said, let's wrap it up.
This morning, after we get an expert report last night that was in the possession of the lead case detective in this case, not some random police officer. Detective Flores is the case detective in this case. I have to believe he understood the importance of that report. And I find it hard to believe that the lead detective in this case didn't bring it to anyone's attention from the district attorney's office until after a jury was impaneled the night before opening statements. I mean, something that they now are saying is such a crucial piece of evidence. In the midst of a trial that's already underway, we would need to locate and retain our own expert to conduct a scientific analysis. Their report was 28 pages. It took them, according to them, it took them 1 week to do this. How long is it going to take us? We have to go find somebody first, hope he's available, the trial will be over. I mean,
All right, so what are you seeking?
what am I seeking?
What are you asking for?
Your Honor, I'm asking, well, and our letters laid it out. I don't need to rehash it, but our letters laid out pretty clearly what we're asking for. There's no way to proceed in this case if this is admitted. We have to either break this whole panel. We need a continuance. We have to start again. What I'm asking for is you conclude this. This is after the jury was impaneled. This is a major piece of evidence that will require us to do a lot of expert work that took them, their own department, a week to do.
Okay, Judge, please know, if you don't know, I absolutely love me a judge that says, I'm not having this in my courtroom. Get it together. It sounds like you're talking out of both sides of your mouth. You know what? I kind of like this judge. I don't know a lot about him yet because I haven't done my full investigation on him, but I like a judge that says, this is my courtroom, and what we will do in my courtroom is listen to me. Okay, Judge, I'm not mad at it in any way, shape, or form. I'm not mad at it. Now, a judge telling the defense team, it is no need to defend everything that they say because I already understood that what they were saying was a reach because of A, B, C, and D. Like, I fully respect that because some stuff does need to be argued. We do need to have what your stance is on something on the record, but you don't need to put every single thing on the record just because they said something. I know that there was a reach because you did A, B, C, and D. He said you accepted the jury yesterday, so I know you don't have a problem with the jury. So him telling me that you have a problem with the jury, he can say whatever he wants, but he cannot prove that. So I don't need you to defend that part. It's no need to waste time defending something that doesn't need defending. He was like, nope, sit down, have a seat. I don't need you to go over that. They're right there. Now, the judge did go ahead and make the decision that he felt like the report should still come in. They just could not discuss and bring up that report at the beginning. He's going to allow them to go ahead and get an expert that they either have a list of that he's provided them, or they can go and get their own person. I'm pretty sure they'll try and go and get their own person just because they don't want no shenanigans. And he even was like, we'll pay for it. I don't think that, the defendant should have to pay for that this last minute. Like, that's fairness. He's trying to be as fair as possible. He's trying to make sure that he is giving a non-biased, fair trial to his defendant that is in his courtroom, and offering to pay for it, even though we know Rocky could cover it. That's not the point. The point is that this was something provided very last minute. I'm willing to be workable with everybody. He was like, I've given everybody my phone number. Y'all can call me if y'all need me. Okay, he getting some cool points. He warming up to me. He warming up to me because that is a commendable thing to say. I do think we need to allow this evidence because it is important to both sides, really. But you do have the opportunity to defend this and find somebody to dispute what they're saying that they found. And I'm going to allow that so that we can move forward because that's the best interest of everybody here because we don't want to waste nobody's time. Okay? Okay.
No, don't interrupt.
Okay.
He didn't interrupt you, don't interrupt him. All right.
It's very clear the defense is not happy with this jury. They made it clear.
Hold on.
Here's the way I want to deal with the latest, recently finding out about this ballistic report. Everybody at the table, all counsel, to me, has great credibility. I accept what all of you say. I don't believe that there's been any nefarious conduct by anybody. What I'm seeing here is that the casings that were recovered were examined, and the opinion is they could have been fired from a Glock 43 or any other number of types of 9mm. You have said that, well, now you want to hire a ballistic expert. That's not fair to you and your client. So this is what I am proposing. We have a list, a Superior Court list of firearm examiners that have been recognized as experts. Contact that person and tell them this is crucial that the ballistic evidence be examined now, not later, but now. The court will pay for it. Mr. Mayers will not have to pay for this. We will. If the firearms examiner wants extra money because it's a rush, the court will pay for it. If you are not satisfied with the people on the list, then if you want to find your own examiner who will do the examination, the court will pay for it. If it's necessary that I speak to the examiner to impress upon the examiner the importance of getting this done ASAP, I'm glad to do that. I am providing my cell phone number to all of you. If you need to call me any time of the day or night, I will speak to you. I will speak to a firearms examiner. If you feel it is necessary, Mr. Tacopina, we can be dark on Monday. But I'm not excluding the evidence. I don't find that there is any nefarious conduct. The evidence is relevant. It's not a smoking gun, but it is somewhat inculpatory. But in and of itself does not mean that your client is guilty. That's the way we're going to deal with this, and that's the final ruling. I don't want to hear anything more about it. That's the end of the issue for now. Are both sides ready for the jury to come in? Do not mention anything about the ballistic comparison in the opening statement.
That was our question.
So,
Yeah, do not mention that.
Understood.
Your Honor, what I was planning on mentioning was that the cartridges found at scene were 9mm. In the defendant's house was a magazine that was 9mm.
All right.
And had some 9mm live ammunition in it. That was it.
If that has been part of the discovery and that was known, then that's fair game.
Yes.
But this ballistic comparison, that's off limits
Correct.
for the opening statement.
Yes.
Understood.
All right, bring the jury.
Now, this is the opening statement portion for the state, and I cannot pronounce this man's name. It is on the screen, but I cannot pronounce his name. So he did get up and start his presentation. He did do some video. He did provide like the video footage that they were able to obtain. They did break everything down, like how it moved from, multiple different locations, because it does, the incident in totality does move from multiple different locations. So they showed the video footage, and he walks through that. This is their case. They're presenting their opening statements, and this is their case. And I don't think I've ever really said this on my channel. I am not a fan of opening statements because sometimes they just be a reach, and it just be like, sit down. But sometimes they do, they are amazing opening statements or closing statements, and they did pretty good. So let's go over a few things. So 2 people did call 911, and they did report the incident that they were hearing, and kind of because it was a moving situation. It did cause for the police, when they arrived, to not know where they were going to find either victims, suspects, things of that, any evidence. They really did not know where the heck they were going because the incident was a movable, situation. So within that, we are aware that Relly states he went back to the location with his girlfriend to find the casings that the police went out there and couldn't find. Warning, red flag. No. He did take a picture and like, this is where I found it at, and then he brought it up there. No. No, sir. I'm not sure why you thought that was appropriate. I don't know what was in your thought process that you said, I'm going to go find it for you. Y'all didn't do y'all job, and I can do it better. Sir, what? Who says that? You can't do your job. I can do it better. I'm going to say I can do your job better than you. Have a seat. Have several seats on that note. Not a fan. You already on my bad list with that right there. Because that thought process, don't do it. Now, in the videos, you can very clearly see after the kind of tussle of the incident, they are leaving the situation and he is behind them. And he wants to be like, oh, well, we were friends. I didn't think he was going to really try and do nothing to me. Like, I even threatened him because I really didn't think he was going to do nothing. But why you followed him? Even if he was like, yeah, y'all was on one, you should have went in a different direction. And said, we're going to have to talk about this tomorrow because you're wrong for that. No, you follow right behind them. And we can see on camera you following them. You're still losing these points here, sir. Negative. I do want to make sure that I state that they did a really good job of showing, like, this is this person, this is this person, this is how you can tell who this person is. Because some of the video footage is very clear and some of it is very grainy, like it looks bad. But you can still kind of tell this is this person because they had on this is this person because they had on that, this is this person because you can see like their hair kind of here, like, because one of the guys has like longer hair and he has on a brighter color, and there's height differences, things like that. Like, so them making sure to show you, like, with these movable locations, this is this person here, this is this person there. So they made that very clear up front. So when that jury gets that video footage, they're not like, who is who? So they did a very good job of capturing, like, each person has like their own color and you can tell where they are, in each scene of the situation. So I do think that that was very good that they did that up front, because we have seen people that have done that and got to the jury saying, can you provide who is this in the video, and then they have to go re-edit stuff. Do it the first time and we don't have to do it again. They did that. I appreciate it. Now, this is my issue. This is your friend for a very long time. Like, we almost at 20 years. I think they said like 18 to 19 years. So you've known each other for decades. And after y'all have an incident, you telling other people, I'm going to get some money out of him, you wrap it up. Wrap that all the way up. We are no longer, even the person he was texting, we was done. We would have been done. There is no way after an incident that is the first thing you say, and it was like hours later. There is no way the first thing out of your mouth is, I'm going to get some money out of him. Besides, you wrong for that. You shouldn't have done that. Why you do me like that? I would have never thought this would happen. You texting other people, I'm going to get some money out of him? Not, and maybe he did say this and they just didn't show the messages where he was like, I can't believe so-and-so did this to me, so-and-so wrong, this my homeboy, da-da-da. It didn't show that, but what they did show is that he stated he was going to get some coins. Why is that the first thing you just was talking about? That should have came later. There is no way that should have came this early in the situation. Absolutely not. And this little graze on the hand, that looked like you fell on some concrete. I'm sorry. It just looked like you fell on some concrete. And you didn't go to the emergency room until you got back to New York? You was in Cali and you went all the way back to New York before you went to the emergency room? You still losing them points.
These cameras capture the initial encounter between the victim, Mr. Efron, who you see there, and the defendant, Mr. Mayers. And you can see that Ills is the first one to intervene to try to separate the two of them. And then at the very bottom of the screen, you see 12E putting his hand to try to also intervene and help separate them. Mr. Myers is an entertainer, and he goes by the stage name APRocky. You will hear other nicknames that he is referred to in the evidence in this case, including Flacco and Luigi. At the time of this crime, Mr. Mayers was 33 years old. He has his own company that I believe is referred to as AWGE, A-W-G-E, that you will hear referred to in the testimony in this case. And as we've talked about, his significant other is Rihanna. The victim in this case is a man by the name of Terrell Efron. And Mr. Efron, you will hear, was also a member of the ASAP collective, and he went by the nickname APRelli. Mr. Efron was also 33 years old at the time of this crime. And what you will hear from Mr. Efron is that he was friends with Mr. Myers well before this case and well before even Mr. Myers was a famous individual. That essentially, I believe they met in high school and grew up together. And Mr. Efron will tell you that at that moment, his mindset about the initial confrontation changed. I told you that Mr. Efron will tell you when he first went there, he believed that this was meant to be a confrontation so that they could strengthen their relationship. Along the top is Vista Del Mar. The parking lot is just out of view of the camera at the top of the screen. Along the top left-hand corner is Selma, forms that intersection. The red arrow is the defendant, Mr. Mayers. And the green arrow is the victim, Mr. Efron. Now, what you see as the video plays is the various cameras on location number 2 switching between 3 different cameras that are mounted to that building. He has these injuries to the middle knuckle of one of his hands. Immediately felt a burning sensation to his hand. You can see just from Mr. Mayer's facial features that he's the one wearing all black. His facial features compared to the video from the parking structure. And then, as I said, the various features of his clothing, the rhinestones on the hood of his sweatshirt in both videos. I played the 911 call for you that LAPD received at 10:18, which triggered their response. And you'll see and hear that at 10:27, LAPD officers responded to the 911 call. And as is their duty, they responded quickly to this call. And you'll hear from the officer that as he's receiving information that's taking him to different locations, he's actually going between the different locations and trying to piece together what happened. But what will be important from his testimony is that he is not given a precise location to exactly where this shooting happened. And with the limited information that he has, he and his partners are doing the best job that they can to find any victims, any suspects, or any evidence. The officer will tell you that they searched the area, didn't find a victim with injuries, they didn't find any of the suspects, and they didn't find any discharged cartridge cases. You will also hear from Mr. Efron that approximately an hour, and he's not precise on the exact time, but approximately an hour after, he himself returned to the location. Now, at this time, the police have already responded and left. Mr. Efron will tell you that he and his girlfriend went there specifically to look for evidence that this had happened. And Mr. Efron will tell you, because he knew exactly where it happened, that he was able to locate 2 fired cartridge cases. And this is actually a photograph that Mr. Efron himself took of one of the fired cartridge cases that he found. Mr. Efron, you'll hear, went to the police 2 days later, walked into the Hollywood police station to report this crime happening. He brought the 2 fired cartridge cases with him, and he gave them to the police. You will hear that the 2 cartridge cases that he brought in were 9mm Luger caliber cartridge cases. However, you will also hear from Mr. Efron that immediately after the shooting, about an hour and a half later, he started text messaging the defendant. And he text messaged the defendant. That was the first message he sent to him. And you'll hear that Mr. Mayer's response was to deny that anything happened. Mr. Efron confronts him again. You set me up to try to take me from my daughter. And the defendant responds, I tried to do what? I know you hate me, I hate you too. The defendant responds again, stop making shit up. Again, denying any confrontation took place. We've already told you in jury selection, and you will hear evidence, that after Mr. Efron sought money from Mr. Mayers, the next day, November 7th, in the early morning hours, 3:40 a.m., you'll hear that Mr. Efron sent a message to one of his friends saying that he wants money. Moving forward in time, you'll hear from LAPD detectives that Mr. Mayer's home was searched on April 20th of 2022. It was loaded with 6 unfired 9mm Luger rounds of live ammunition. Defense will call 12B, Mr. Phillips, to testify. Again, he's friends with all these participants. He's 32 years old. And it is expected that he will testify that the defendant fired was a starter pistol. That, ladies and gentlemen, is what the evidence in this case will show at the end of this case. As I've said, we expect that the defense will attempt to present an alternative explanation for what happened that night. But we ask you to do one thing, which is, as you evaluate the evidence from both sides in this case, to not leave your common sense at the door. And wait until the end of the case, when you have all the evidence, to make your decision, listen to the court's instructions on the law, and return the only just verdict there is. Thank you.
So I mentioned this earlier, that I'm not a big fan of opening and closing statements, and this right here is why. They are allowed in the opening statement to kind of storytell. They are allowed to kind of elaborate, give this drawn out opinion, narrative kind of situation. Some attorneys feel like that opening statements and closing statements should be very factual, and some feel like they should be able to add the color they want to their opening and closing statements. That is the method that APRocky's lead attorney, Joe Tacopina, went with. And I don't have an issue with his actual opening. I have an issue with the fact that the state decided to object several times. Can't stand it. I absolutely cannot stand when an attorney objects during an opening and closing statement. It gives the impression of insecurity. Because all you have to do is, if they're stating stuff that is not a fact, that you have evidence to prove otherwise, is prove otherwise. You should really be letting the jury get a feel for this attorney, kind of get a feel for the case they're going to present, and you objecting, it doesn't go well. It just doesn't go well. So they did that a lot, and it was distasteful to me. It was very distasteful. They should have just let him run and then said, hey, judge, this is our issue. I digress.
I make promises to you right now. You get to see if we fulfill those promises. And then you vote. Listen to the evidence carefully before rendering your decision. You promised. And to base your decision only on the evidence. Not some preconceived notions stemming from the nature of this case or what you may have read or heard.
This is entirely arguable.
But just on facts. I submit to you the decision you make in this case at the end will be the most important decision in the life of Rocky mayors. And I'm confident that if you apply the standard and hold the prosecution to the burden of proving each and every element of both counts, beyond that doubt, the reasonable doubt, this will work out. Ladies and gentlemen of the jury, my name is Joe Tacopina, along with Sarah Kaplan and Chad Siegel, have the absolute honor and privilege to represent Rocky Mayors, known globally as ASAP Rocky. The evidence will show you that Rocky was a self-made man, risen from the most humble beginnings to extraordinary successes through work, dedication, and artistic
Your Honor,
brilliance.
this is argument is also irrelevant.
Overruled. What is said in opening statement is not evidence. What is evidence is what can be proven.
May I say? Sorry.
Sometimes things are said in opening statement that cannot be proven and are not proven. Sometimes they are. That's what this case will be about.
Remember my promises, because I'll remember theirs. When we talk in a few weeks on closing statements.
Something that I really did like that he did that I have not seen an attorney do is that he said, this is my promise to you, this is what I'm going to do, and if you feel like I've lied to you, then you're going to hold that against me, because I'm supposed to be telling you stuff that I can prove, stuff that I have documentation of. I'm supposed to be able to bring it to you. So if I tell you I'm going to bring it to you and I don't, then you have every right to hold it against me because I lied to you. So he said, put it on me. I kind of appreciated that. Put it on me because this is what I know I got. Confident.
You'll hear he was born in Harlem, like they said. He was raised in poverty.
Your Honor.
You'll hear that
Your Honor, the same objection.
Stop. Overruled.
You'll hear about his upbringing, his mother and his siblings, and how he overcame with hard work, with dedication, and with talent. He's not only a celebrated artist and a fashion icon, he's a man who raised a beautiful family, as the district attorney put the picture, his significant other.
Your Honor.
Just you got to get to the facts.
You're going to hear the stark contrast in two individuals, Rocky on one side, Paul Efron on the other side, posting pictures of himself with large sums of cash and whatnot. It's fraud. He is all about a money grab. Ladies and gentlemen, this case is all about money. I've said it once, twice, I'll say it a few more times. The evidence will make clear that Relli is trying to leverage a fabricated story to extract money from Rocky. The evidence will show you that Relli is a blatant perjurer, someone who takes an oath, and despite that oath lies. The evidence will show you, and you will see him commit perjury right before you in this court. The evidence will show that despite all the evidence they claim to have, all of it, and I mean all of it, will rise and fall on the word of Relli and his credibility. Period. End of story. After tragedy had struck another member of this ASAP group, an individual named ASAP Josh had untimely death, he passed away. Evidence will show you that Rocky stepped up, spoke to the parents and the mom, ASAP Josh, and offered to cover the cost for the funeral, bring the body back to New York and pay for the funeral. But Relli, still blinded by resentment, believed otherwise. He thought for some reason Rocky didn't agree to pay, or had agreed to pay, but then didn't actually pay. And he was furious. He went as far as to threaten physical violence against him because he thought he didn't pay for the funeral or for the expense of flying the body back. He was wrong, because he did pay. But he went as far as to threaten physical violence. And you're going to see that for yourself, ladies and gentlemen. On October 16th, a few weeks before this incident that you're all here to hear about, Relli told his friend that Rocky was a piece of shit. Now it's funny, they showed you a lot of text messages. I didn't see that one. Did not see that one. That's the catalyst. That's weeks before this incident, when he came in hot on November 6, 2021 on Argyle. And despite Rocky's best intentions, the evidence will show you that Relli was angry when he agreed to meet Rocky that day. And that anger came to a head when he encountered Rocky on the street, outside of a parking lot, on Argyle Avenue, leading to a brief altercation that took place on the street, which you saw a clip of, a very short clip of. The DA said that Rocky was the aggressor. There's a video there. It also shows that what followed was a very quick scuffle, again you saw it, with Relli making physical contact and pulling Rocky towards him. Not Rocky pushing Relli, who outweighs him by almost 100 pounds. Not Rocky pushing Relli, but Relli pulling Rocky. The DA said in his opening, he said that Rocky was pushing Relli. You know who else said Relli was pulling Rocky? Relli said that. Relli in a statement. And when he watched the video said, yes, I was pulling Rocky this way. The evidence will show, in fact, that he was the victim of prior violence, which caused him to have to carry this. Victim of home invasions, victim of a stalker at that time, in November of 2021, victim of a slashing on his face, which he still carries with him today.
Your Honor, there's been no
So if all the friends know that you have this because of safety reasons, we have to assume that they all knew. Especially if there are going to be multiple people coming to the stand to say, yes, we all knew that about our friend. He states that based on the things that were going on in Rocky's life at that time, he had a stalker, he had several incidents with people, that his friends all knew that the weapon he was carrying was not a real weapon, that it was a prop because of the situation that he had been in. So most people knew this, but I'm not sure. But he was licensed to carry. So if he wanted to carry a weapon with him in California, he was licensed. There was no issue with him having an actual weapon on him. That just wasn't the route he wanted to go, which is why he had that prop weapon, advised by his security team to do so. So that is kind of the route that he went with. And he's stating, you know, my friends knew that. This is why they, you know, what the basis is of me doing such thing. So it does sound like this was not a secret. It does sound like them as a group knew why, how, all that jazz.
By the way, folks, listen to this one. Rocky was licensed to possess firearms and licensed to carry firearms in November of 2021. He was licensed by the state of California. He could have legally had his own firearm. He comes up with that left hand before Rocky raises his right hand. And how do you know that? He has his hand around Rocky's neck or shoulder, and Rocky's right hand then finally comes up. Boom. This guy has his hands around Rocky's neck or shoulder before Rocky's right hand comes up. Boom. And then you heard and you saw in the video, they're going backwards. Relli, again, who's much bigger, you can see that from there, said to the police, yeah, I pulled him back. I pulled him back. They told you, well, Rocky pushed him back. That's all Relli said. Defies sort of the laws of physics. He outweighs him by almost 100 pounds. Relli pulled him back. The police are searching with flashlights. And there's 1, 2, 3, 4 right there right now. There were 7. There's another one here. This is where the alleged tussling was with Relli and Hills. Rocky's here. 12's here. Here's the corner they came around. Were
like easy on the screen.
were discharged according to Relli right here. Okay, right here. Look at where they're searching. This is where Relli, as he comes back an hour later and picks it up. And here's the landmark. Look, this is the corner that they all came around, right here. And this is where it all started. And here, there's that opening right here. See this big orange, red, whatever this thing is here? Look at the picture below. Okay. That thing there is that thing here. That opening here, this is a big orange thing. I mean, you can't really see this well here. You'll be able to take these with you later. This is that orange thing. A few feet there is where they're searching. You know where that is? That's really an hour later. According to the police, they captured that surveillance video. That's him an hour later, coming back to retrieve the bullets in the exact same spot at the, go ahead up. The cops were searching with a flashlight. And the cops weren't there looking for, they didn't know what. The cops were there looking for shell casings, who miraculously found them in the dark an hour later after 7 trained officers with searchlights in the same exact spot couldn't find them. So much for the officers didn't know where to look. They were right in the same spot. Who the hell can get his payday? But ladies and gentlemen, at the end of this case, after all you've seen and heard, all the evidence and cross-examination, all the things I promised you today, I would ask at your hands for a verdict of not guilty for Rocky Mayers. It's the only verdict consistent with justice. It is the only verdict consistent with fairness. Thank you.
Now, he goes through the videos, he did like a quick pass through the videos, and then he went through it, telling it from the side that he feels Rocky is saying this is what happened. So he went through that, and he's stating that Relli was the aggressor. And prior to this incident, there were text messages that Relli was sending that indicated he had a big problem with Rocky. So there was some tension there, and everybody knew that. And some of the other guys in the group were trying to reach out to him to say like, hey, he wants to make sure everything is good. Like, let's kind of do that. So besides the two of them knowing this information, the other guys knew this information. And as friends, they want to make sure it's smoothed out and, you know, like everybody's good. Like they're already dealing with that situation of their friend who had just passed away. Like they're all on edge, and they just want to, you know, kind of balance back and regroup as a group and move forward, because that's what you have to do. You have to keep going. You have to keep pushing. And it's definitely also worth mentioning that there were no prints from Rocky on the actual casings that were found, which definitely understandable. I mean, chain of custody was broken. Relli's going out there to find the casings. So is that a big deal? Probably not really, but it is just something to note that there were no prints from Rocky on the casings that were turned in.
Oh, and speaking of judges, you both know this. I know that in the heat of battle, it tends to happen. I don't want speaking objections. Speaking objections are explaining to me why you are making the objection. If you make an objection, I know why. So just state the objection, state the legal grounds, but don't explain to me why. Everybody on the same page?
Yes.
Okay, all right.
What?
What? Does it relate to his opening statement?
It does. My co-counsel got up, he gave a legal opening statement. He didn't argue. He didn't bring up areas that are outside of what he was supposed to discuss. Counsel got up, and he basically gave an argument start to finish. I know it, the court knows it, he knows it. The problem is, I don't think he cares, because basically, he just talks about whatever he wants to talk about.
Don't make aspersions.
The court remembers, I said yesterday to counsel in the court, all that I ask is if there's an area that you're going into that is not absolutely clear, you approach and you make sure you can do it. So Your Honor, it's not just a disrespect to me, to my co-counsel, it's a disrespect to the court, because he has basically decided, I'm going to say whatever I want about the victim, and I don't care whether it's going to be allowed by the court. And the problem is the court...
I see your point.
Okay.
Why are you telling me this now?
What I'm requesting is I want the court to instruct this jury specifically and very simply. Defense counsel made certain allegations. He called the victim in this case a criminal and a perjurer.
I know, I'm not going to do that. What I will remind them is, nothing that you say or any of the lawyers say is evidence. That is what I'm willing to remind them of that. And that's the end of the issue.
So earlier someone mentioned, oh, well, the judge should be getting on all parties involved equally. And I was like, he did. This is him doing so. Not every judge is a no speaking objection kind of judge. Sometimes it's great because it does make things a little bit smoother, but sometimes you need to know what they're objecting to because you don't know yourself. So you don't get to really understand because they know. But if we don't get to hear why they object, and we kind of be like, what they object to? So it's a catch-22. Sometimes it's good that that's a method that they prefer, but sometimes it's kind of like, what are you objecting to? In this opening statement, it should have been a no speaking objection. What he was objecting to should not have been mentioned at all because he should not have been objecting in the first place. But the judge saying, going forward, I just want to make sure everybody knows, I'm not the type to, don't start telling me why you objecting to nothing because they already given that ruffled feathers vibe. So y'all going into it too much is not going to work for him. And so he said, yeah, I'm going to need to nip that in the bud now, but thank you. He said, why did you mention this? Why are you telling me this? And the prosecutor kind of goes into why he feels like he should be, saying this, blah, 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 blah to the jury. And he's like, I'm not doing that. What I will do is remind them that the information y'all go over in the opening statement is not a fact. But that's it. I'm not going to tell him all this blah, 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 blah that you want. No, thank you. He's like, I'm not about their life. If you want to do all that, keep it to yourself. I'm in charge here. I'm not doing all that. So the first witness for the state was Sergeant Thomas, and they should have left him off the stand. This was a terrible witness for them. Lord Jesus. Now, and I also heard that he's somebody's son on the Real Housewives, I think of Orange County. One of them California Housewives shows. He's somebody's son. Not that that's important, but he is somebody's son. He went over the incident. They did his whole body cam, like from him getting the call, going out there. While he's out there looking for any evidence, he's kind of like, are we sure that this is a valid call? Like, he's kind of like, this sounds like it could have been a prank. And he's saying that on camera. Of course, it's just, of course, it's body cam, but still, like, it's on camera, him saying that. So he has doubts. He's expressing his doubts. He doesn't think this is real. He thinks this is a waste of time. He thinks it was a prank call. And the bad part is when it gets up there to question him, he's like, so did y'all talk about what you should say on the stand? He's like, well, we talked about it today. Today? Before you got today, like, you on the stand today and you just talked about it before you got on the stand today?
The possibility that you may have missed something. Remember that line of questioning the prosecutor asked you about?
Yes, sir.
You're not training to miss something, you're training to find things, correct?
Correct.
All right. When was the first time you discussed the possibility that maybe you missed something with the prosecutors? When was the first time you discussed that?
I mean, today we reviewed stuff, right?
I don't know. I wasn't there. Today?
Correct.
But it was the first time you discussed maybe I missed something.
Yeah.
When did this happen?
This was in 2021.
Huh. And what's it now?
This is 2025.
Okay. So today's the first time you met with him?
Met with them in person? Yes.
And the first time you discussed testimony was today?
Yes.
You didn't discuss it on Wednesday?
No, we discussed scheduling and what the case was about. That's it.
So that is a wrap on day one. It is possible that they may go dark on Monday because of the issue with the ballistic report. They may decide to try and find somebody to, do their own ballistic report. So it's possible that there may not be court on Monday. We won't probably know until Monday, kind of depending on what they decide to do because they did not show anything at the end of court. But we will see what day two brings us in the APRocky trial.